But what comes into your head when you hear someone talk about walking the line? Anything come into your head?
Johnny Cash.
Johnny Cash, Johnny Cash. Johnny Cash, famous song, I Walk the Line, was about the line between balancing life on the road with being, honouring his commitment that he had made to his partner. So the line that we in integrity bodies have to walk is not such a personal one, but it's still one that's critical to our everyday operations. So on the one side of the line is transparency. And transparency seems to me, it's a concept a bit like motherhood. How can you argue against transparency? Isn't it inherently a good and wholesome thing? Shouldn't integrity bodies be transparent in their operations? Shouldn't their decision-making processes, and indeed the matters about which they are making decisions, be clear to all? So far as it relates to the examination of witnesses, isn't it a good thing that they are conducted in full glare of the public, so that we can see what's alleged and we can hear the person against whom the allegations are being made respond to these allegations? On the other side of the line is welfare. The matters that integrity bodies are concerned with are not, merely academic matters. They are matters that affect the lives and frequently the livelihoods of human beings. Shouldn't that be an important consideration, an important factor in our decision-making processes? Shouldn't they be protected from unnecessary and unwarranted harm? So before diving too much further into this balancing act, I think it's important to tell you a bit more about who these decision makers are, what kind of bodies they are, what kind of body is an integrity body. Perhaps it's best to start by telling you who we are. So the Victorian Inspectorate was established in 2013 by the Victorian Inspectorate Act of 2011. And we were set up to oversee other integrity, accountability, investigatory bodies and their officers. So currently there are 14 bodies in relation to whom we've got some form of oversight responsibility. The one we have most to deal with is the Independent Broad-Based Anti-Corruption Commission, IBAC for short. But we also have, among others, the Victorian Ombudsman, the Office of the Victorian Information Commissioner, the Victorian Auditor General's Office, the Office of Chief Examiner, and Wage Inspectorate Victoria. Principally for these bodies, what we're doing is reviewing their exercise of coercive powers, that is their power to require someone to appear as a witness or produce documents or issue other kind of process with which you must comply. We're an independent office, not subject to ministerial direction or control, but accountable to Parliament through a committee of the Parliament called the Integrity and Oversight Committee. We ourselves have a range of coercive powers that we can use when investigating the conduct of officers. Within 8 of those 14 bodies, there's 8 of those bodies that we can investigate conduct allegations in relation to. And it's important to say that while we have, for example, the power to summons persons and summons documents, we're not a court. We are an administrative body. And we're not the only administrative body, because IBAC, Victorian Ombudsman, the other bodies that I mentioned who have coercive powers are also administrative bodies. They are not judicial bodies. So while they have far-reaching and extraordinary powers and can override many of the rights that we regard as fundamental in our society, they cannot, for example, find you guilty of an offence. They cannot impose a monetary fine on you. Indeed, in a strict legal sense, their findings have no effect on your legal rights. But through their power to report and make recommendations, they can set and train a process that can have an effect on your legal rights, that might see you ultimately brought before a court or a disciplinary body on a charge of some kind, that might see you dismissed from your employment or might even see you imprisoned. And courts operate in accordance with strict rules about what is admissible in evidence. The administrative bodies that I am talking about are not bound by the laws of evidence. So in the next few examples, I'll be referring particularly to IBAC, and I'm doing that merely because IBAC is the only one of the bodies that I've referred who do conduct public examinations. So material aired by IBAC and put to a witness in a public hearing may not be able to be put before a court. The material may be what's referred to as hearsay evidence, evidence of what someone else said to the witness, not what the witness is directly saying. It may be evidence that was obtained only because IBAC was able to override the privilege against self-incrimination, and that's something that a court cannot do. And yet, in a public hearing, all this kind of evidence can be put before the public. And doing that may even impact on the capacity of that witness to have a fair trial, if ultimately there is a trial. In a criminal court, the judge or the jury must be satisfied beyond reasonable doubt. Now that's a pretty demanding standard to meet, beyond reasonable doubt. IBAC, and indeed ourselves, and the other integrity bodies are referenced, can make a finding about the existence of a fact on a lesser standard, the balance of probabilities. Something is more probable than not. So that's a much lesser standard. So you can have the result that on the same evidence, a court and an administrative body can come to a different conclusion. Another distinction is that in a court you have got two sides presenting a case before an independent umpire. The judge is not aligned with either of the parties. They are there to see that the case is presented in strict accordance with the rules of evidence, and that parties get to fairly present their case and can examine and cross-examine witnesses. In a public hearing before IBAC, it's quite different. The presiding officer, whether it's a commissioner or a deputy commissioner, is not an independent umpire. They will have played a big part in deciding what evidence is to be presented, what questions are to be asked of the witness. The evidence will be presented and the questions will be asked by a lawyer who's either employed by IBAC or engaged by IBAC. Even if the witness is legally represented, there are limitations on what that representative can do. In a public examination, they can cross-examine, but only with leave of the commission. There's no cross-examination at a private examination. While there is an opportunity to make clarifying remarks or ask clarifying questions of the witness at the end, it's not in the same position as you are in a court proceeding. The same position applies in the VI and Ombudsman and the other same bodies. So we're holding this Law Week presentation today in our hearing room. The signs on the door, you're pretty clear where we are. And now at the VI, we do not have power to examine witnesses in public. All our examinations are held in private. But when you look around this room, do you think it would be a pleasant, relaxing experience to be summoned to come in to here, for you to be directed to sit over at the table where Cathy is sitting, to have a lawyer sitting at the table just here in front of me, tasked to ask you questions about your conduct or about conduct that you may have witnessed in the course of your work, with you being required to answer those questions or face prosecution for failing to answer without a reasonable excuse, and with someone sitting up there presiding over it all and indeed also asking you questions. So does anyone here think they would be comfortable in that situation? I don't see too many people indicating that. Now, of course, there is a clear need to have a body like IBAC expose corruption and improper conduct, whether it's in the police force or in civilian society. It's good to reference there's an organisation called Transparency International, and it's a global non-government organisation that now works in over 100 countries. And their task is to combat corruption and promote transparency, accountability and integrity at all levels of society. And in each year since 1995, they have been publishing an index, pardon me, called the Corruption Perceptions Index. It really gives a snapshot of the levels of corruption within a particular country. So the index uses a scale of 0 to 100, with 100 being very clean and 0 being very corrupt. So in 2022, Australia was 13th with a score of 75 out of 100, while New Zealand was second with a score of 87. But if you look back to 2013, which is the year that IBAC commenced operations, Australia was 9th with a score of 81. So it's pretty clear that in Australia as a whole, we've still got work to do to combat corruption. And to do that work combating corruption, it is appropriate that IBAC has all the necessary tools at its disposal. And one of those tools is the power to examine a witness at a public examination, at a public hearing. But that raises the question, when can it be said that it's in the public interest to do that, to use that tool, to examine in public as opposed to in private? When can it be said that it's in the public interest to name a person in a public report and make adverse findings about them, as IBAC and the Victorian Inspectorate and the Victorian Ombudsman, as well as others, can do? So to explore these complex issues that face anti-corruption commissions and other integrity bodies when deciding between public and private hearings and public and private reports, a pleasure to hand over to Cathy Cato. Cathy.
Thanks very much, Eamonn. Thanks for all coming today. So this very important question we'd like to explore today: how do decision makers weigh what is in the public interest? Since the creation of IBAC 10 years ago, the Victorian Inspectorate has overseen IBAC and other integrity bodies, and we've also conducted our own investigations of public interest disclosures. So through these activities, we've been the decision maker, we've observed the decision makers, and we've made recommendations to the decision makers. And the guide to how the decision makers must walk the line is the law. The laws that Parliament has given us and what the courts have said about those laws. So today we'll explore the public narrative regarding these issues. We're going to provide observations from our own experience and draw your attention to the legislative changes and the public reports that do influence integrity bodies on these issues. So I'm going to start with looking at public hearings and transparency. Eamonn's introduced that issue. So the recent creation of the new National Anti-Corruption Commission, known as NAC, well, perhaps it may or may not be known as NAC, that's what we'll call it today. It led to much discussion last year about whether there should be public hearings, and if so, what's the appropriate criteria for deciding to have the public hearing. So as Eamonn has discussed, transparency really does sound like a fair way to combat corruption. Even the global organisation, as he said, is Transparency International. And while there were many submissions to the Commission about the Commission seeking transparency, the debate was nuanced. There are competing principles that must be considered. For example, Transparency International Australia submitted that the holding of public hearings or even partial hearings is important to build the public's trust. It's important to bring new evidence to light, and it's really important to investigate corruption and to do that really effectively. But despite this starting point, they also support the principle that compulsory investigative hearings should normally be held in private unless there is a clear public interest in having a public hearing. similar to a royal commission, where the governments have decided this is an issue that needs to be aired. In particular, they consider that the hearings should be in private if a public hearing could impact safety or if it could impact criminal proceedings. Now, in New South Wales, public hearings by their Anti-Corruption Commission, ICAC, they've been frequent. And in Victoria, we've had IBAC for the last 10 years, and I think over that time, we've seen a growth in the number of public hearings that are being held. So what has the Commonwealth Parliament decided will happen nationally? Well, the NAC commences in 6 weeks, on 1st of July. So it's quite timely to be discussing these issues. And the Commonwealth Parliament has decided that the NAC will conduct private hearings, but if it is in the public interest and exceptional circumstances justify doing so, they may conduct public hearings. And given the importance of fighting corruption, how can it ever be in the public interest to hold a private hearing? Let's just talk a bit more about that issue. So Eamonn's talked about, transparency sounding like it's the right way to fight corruption. But what he has talked about are the really significant differences between administrative proceedings and criminal proceedings. And as an oversight body, we receive complaints about the day-to-day impact that these public hearings have on the witnesses' lives. We have impacts on their safety and well-being. They're talked about in the legislation. But witnesses report other things. They report losing their jobs. They report having their bank accounts closed. And one of the issues we need to think about is that some witnesses may ultimately be prosecuted for the issues that are raised in that Anti-Corruption Commission public hearing, but others may never be prosecuted. The damage has been done at that point, and there's little recourse to clear their name. And another factor that has really changed the way that public hearings are impacting on witnesses is that since COVID, there's live streaming. So live streaming of public hearings really does make them available widely to the media and to the public. So there was an independent performance audit of IBAC in 2022, and there was a report issued in October. And there is data from that report that shows the really important reasons for having a public examination. They're a really important tool in educating the community through exposing real-world corruption, showing real examples of what that corruption is and misconduct, so that we're not just thinking about corruption as a concept. We need to look at those examples to help us think about them, remember them, for public servants to know what they shouldn't be doing, and really for those interacting with public sector agencies to know how they should be engaging as corporate bodies. And while, though, this live streaming increases transparency, it can have that irreversible impact on those witnesses. The data from that audit report showed that the hearings for Operation Watts attracted 278,000 views over a 4-week period. So in that context, where we've got both sides of the line, how do the decision makers decide what to do? Well, the law that guides IBAC is clear. IBAC must hold those examinations in private unless it considers on reasonable grounds that there are, yes, that phrase, exceptional circumstances. We've heard a lot about that. Whether it's in the public interest to hold the public hearing, whether the conduct being investigated may be serious or systemic corrupt conduct, or serious or systemic police personnel misconduct. And then the last one is really the touch point of what we're talking about today. IBAC must be satisfied that a public hearing can be held without causing unreasonable damage to a person's reputation, to their safety, or to their well-being. The law in Victoria also provides further safeguards before public hearings can be held. 10 days prior to the public hearing and before any public announcement of the hearing, IBAC must provide a written report to the Victorian Inspectorate setting out its reasons for having that public hearing. That's a very important safeguard. Another one is that IBAC can hold parts of its series of hearings in private. And importantly, the legislation changed in January 2020 so that witnesses are also able to apply for a private hearing, or to have at least part of their hearing held in private. So when IBAC thinks about the application for that private hearing, it then goes back into that public interest test and back into considering the unreasonable damage. Is there unreasonable damage to reputation, safety or well-being? So what is our role as the oversight body there? Well, we provide an extra safeguard there because they give us the report. We then review that report and we look at whether that report shows that IBAC has applied the lawful requirements before a public hearing can be held. So we can make recommendations after we've reviewed that report, but we cannot require IBAC to do anything. So it's a safeguard, but it's not control. As Eamonn said, we're an administrative body, we're not a court, we can't make orders about these things. So we've talked about one side of the line. On the other side of the line, we need to look at what guidance there is when decision makers are thinking about witness welfare. What do we have to think about when we're concerned about that, each witness? The starting point, of course, is the legislation. The Occupational Health and Safety Act is our starting point, and we must take all reasonably practicable steps to protect health and safety. We also get more guidance from reports. So the first report that was tabled in Parliament about this issue, about the witness welfare in private hearings, was actually by Eamonn in 2018 on behalf of the Victorian Inspectorate. It's been described by the Parliamentary Integrity and Oversight Committee as a seminal special report on IBAC's management of witness welfare. The report did deal with two incidents. The Victorian Inspectorate conducted an investigation and inquiry into those incidents, which were about the health and safety of witnesses, and in the particular circumstances, their welfare was seriously compromised. Those incidents didn't arise from public hearings, they arose in private hearings, and we made 10 recommendations for improvements in those areas. Now, it's important to say IBAC did not accept the findings or the recommendations, but they subsequently completed an independent review of their management of witness welfare management, and they made many improvements from that time. And since 2018, where it all started, we have continued to provide private feedback to IBAC and to other integrity agencies about improvements that can be made to their management of welfare. And we, as a body, are continually improving our own approach to witness welfare. So the other part of the guidance that we get is from laws as they change. So in January 2020, the law guiding integrity bodies really has changed to protect witness welfare further. So what they did then was they looked at what's happening in an investigation process that is impacting on witness welfare without anyone doing anything else. And one of the issues was confidentiality notices. So sometimes they're put into place in an investigation. It sounds quite onerous. So someone is asked to be a witness in an investigation, and you can imagine coming into this room and having to come to a hearing like this and not being able to tell anyone. So a confidentiality notice is quite onerous, but it has a really important purpose. Its purpose is to protect the reputation of those that are being investigated, because they're investigating allegations. They may go somewhere, they may not, and reputations of the subjects of the investigations will be damaged forever. So they do play an important role, but what the legislation change was designed to do was really just to make sure that those that were covered by that notice could speak to people that could help them. They can speak to their spouses, their partners, and also to medical practitioners. So those safeguards are in place in the legislation. So that's the default position, unless there's a very good reason for the integrity bodies to take another view, then those protections are there. So we've had the law, we've had our report. That takes us from 2018 through to 2020. More recently, what we've had are two really important public reports that have really informed this area. And that one of the reasons they've been so important is that they have been guided by expert advice in this area. So they really do bring out some of the best practice principles that should be followed, and they make some important recommendations, including to the Victorian Inspectorate as a body and to government about further reforms. The first one I'd like to talk about is a Victorian report, and we've already discussed a couple of times today that we as integrity bodies, the IBAC, the Victorian Inspectorate, the Victorian Ombudsman and OVIC with the Information Commissioner, we have an oversight committee. So the watchdogs have a committee of Parliament that looks over us and makes sure we're doing things appropriately. And the way they do that is through these public inquiries, and they take submissions and we answer questions. And then they publish reports. And in 2022, in October, they did publish a report that focused on the management of witness welfare. So it was a really important report that took submissions from very important and informed bodies. It took submissions from the public, and it came to some conclusions about how we as integrity bodies were managing these issues. The conclusion was that the body's policies, procedures and practices do reflect a serious commitment to ensuring the welfare of persons that are involved in investigations, and it also identified areas for improvement. So I just want to take you through what the best practice principles from that report are. That welfare support should be appropriate and effective, that it should be provided proactively, and that it should be provided by persons with clinical expertise and experience. So the recommendations they made, there are a number of them. I'll just summarise it by saying they made recommendations for some legislative reform, most of which were about issues that were already being put into place by the various integrity bodies. And they made various recommendations to each integrity body that essentially reflected the maturity of that particular entity in terms of where they were at with witness welfare. So once all of these recommendations are put into place by the integrity bodies, we'll essentially have integrity bodies that have really strong best practice witness welfare frameworks, and they will include independent counselling and support services for witnesses, particularly those most at risk. They'll be capturing data that helps identify risks and move forward with really help the identification of those risks really will inform our actions moving forward. So it's important that it's a continual process. And they also wanted various bodies to explore the feasibility of taking further steps. Some steps include like providing outreach to witnesses. Now, it's okay for an integrity body to do that, but when we're engaging counselling and support services that can help witnesses, the obvious thing that an integrity body wants is for that outreach service, that support service to contact the witness and check that they're okay. But of course that crosses boundaries that those professional psychologists have, so they can't do that. So what the committee has said to, I think this one was to IBAC, was to explore the feasibility of whether you can get informed consent from witnesses to allow the bodies to the support services to step in at that point and really check in on the witnesses. And they also wanted bodies like ours to look into the feasibility of having an independent welfare liaison officer so that the person contacting witnesses isn't always the investigator. Of course, our investigators are extremely careful and very friendly and polite with all witnesses, but it'll be interesting to see. We're currently having our witness welfare policy reviewed by an independent expert. That was one of the recommendations for us, and they'll also be looking at that issue. Is that appropriate? And if so, what's the best way for us to go about doing that? Now, unfortunately, we don't have time today to talk about our witness welfare policy vis-a-vis complainants. It does extend to complainants, and the review of the policy will include looking at how it looks after complainants as well. So we'll be ensuring that it meets best practice principles, but there's a whole lot of other issues there that if we go down that avenue, we won't have time to be talking about witness welfare. So we've talked now about the Victorian public report that's been so informative. The second one that's really quite an extraordinary report is a report that was published in January 2023. It was tabled in the New South Wales Parliament, and it was tabled by the very new inspector at the time, who'd only been in the role for about 6 months, from 1st of July last year to January 2023. The inspector is the inspector of the New South Wales Anti-Corruption Commission. Her name is Gail Furness, and she decided to do an audit of the welfare of witnesses and other people involved in ICAC investigations after being informed that an ICAC witness had taken their life soon after giving evidence to ICAC. And there were 2 other incidents that were also reviewed. So the audit looked at the approach of ICAC in respect of those 3 witnesses and looked at whether or not its own welfare procedures at that time were followed. The finding was that they were followed, but the really important part of this audit is that Simon Brown-Greaves, who is an independent expert in this area, who I think has done a lot of work already with integrity bodies, he was engaged through this audit to provide the expert advice and to look at it all from the expert point of view, look at the entire witness welfare framework that was set up by ICAC and make some recommendations in that regard. So we had, coming out of that report, some best practice principles set out in his part of the audit report, and then some recommendations from him and from the inspector overlaid on that as well. Now, I just want to talk, I'm going to quote, it's a bit of a long quote, but the inspectors forward to that report really did articulate the balancing act that we're exploring today, and it shows that these issues are relevant beyond Victoria. So what she said was, "It is widely accepted that an effective ICAC is critical in instilling and maintaining trust and confidence in public administration. It does this by, among other things, investigating, exposing and preventing corruption in public office in accordance with the law. Along with other integrity bodies, the Commission has significant coercive powers, including requiring persons to produce documents and attend compulsory examinations, which are held in private, as well as public inquiries. These powers can be exercised many times during the course of an investigation, and there is no doubt that the process of investigations is often long and emotionally demanding for those involved. They can negatively impact on a person's psychological well-being, as well as those close to that person. And it is not only when the outcome of an investigation is known, but the investigative process itself that can threaten the reputation, employment and welfare of those involved. And when a hearing is attended by significant media attention, the impact can be heightened. So in light of the findings of the New South Wales Inspector and Victoria's Integrity and Oversight Committee, integrity bodies must continue to ask the following questions during investigations when laws require consideration of safety and well-being. What is the impact on witness welfare, and how can we minimise the impact on witness welfare? And for IBAC, who has the power to have the public hearings, there's that extra consideration: when is damage unreasonable? So I'd like to conclude today by discussing how these issues arise in the context of a public report. So that New South Wales report from the inspector there identified 2 stages of integrity body investigations which can impact people. There's the investigative process, both with respect to public and private hearings, and then there's the outcome of the investigation. So we've talked about that most bodies are conducting their investigations in private. We can't undertake public hearings, but what we can do, just like IBAC, is issue a public report. Just like the one we've been talking about, the 2018 report about those witnesses at the IBAC hearings. And what these public reports do is they explain the outcome of the investigation. They make recommendations for improvement. Just like public hearings, they provide that level of transparency that can help prevent those future issues occurring. And that's a really, really important step. We've seen what the 2018 report did. It started this whole discussion. All of the changes that have happened in the integrity bodies started with that report. So these reports do have that extremely important role, but they can also impact those involved in the investigation, even when they're not named in the report. So when you're balancing those 2 things, how do you decide whether to table a public report? Of course, we're guided first by legislation. Under the Victorian Inspectorate Act, we can make recommendations that include taking action to prevent the specified conduct from continuing or occurring in the future, or to remedy the harm or the loss that has arisen from the conduct. And of course, these recommendations can be made privately, or we can make them publicly in a report. What else we've done to help demonstrate transparency in how we, the Victorian Inspectorate, make these decisions is publish integrity response guidelines. So they set out the criteria that we use to help balance the public interest, how we walk that line. The public interest considerations include whether the transparency of and the exploring of the issues in a public report is necessary. We look at whether it's necessary to do quite a number of things. Is it necessary to inform and warn the public about the unlawful behaviour? To encourage compliance? Compliance is always, encouraging that compliance is the main reason we make really the centre of why we will make a decision to respond in a particular way to the conduct. We want to deter future unlawful conduct by both the integrity body and, in many situations, other integrity bodies. That's why it's in the public interest, because it goes beyond just the relevance of that particular body. We'd like to raise awareness about expected standards. And again, we go back to what it says in our Act about remedying any loss. But we must always balance these considerations with the following question. Would a public response which revives the issues in the public domain cause more harm to those that were affected by the conduct? So decision making that weighs these decisions is not easy. But what we are is confident that in Victoria, integrity bodies are embedding best practice principles that relate to witness welfare into their decision making, whether it's relating to public hearings or to public reports. And with the New South Wales inspector who published that seminal report in January, now appointed as the inspector of the National Anti-Corruption Commission, it is likely that the careful balancing of the witness welfare and transparency considerations will also be an important focus at the national level. So to provide some concluding remarks, I'm going to hand you back to Eamonn. Thank you.
So I think it's fair to say that walking that line between transparency and welfare is not easy. As outlined by Cathy, there are complex and competing principles that must be considered and balanced. The way forward on any particular matter is not black and white. It very much requires nuanced consideration. We don't want the perpetrators of corruption or other improper conduct to go unpunished, but the punishment must be appropriate for what they have done. As I mentioned at the start, we must never forget that caught up in all these matters, it is real, living human beings that are affected. Cathy referenced the instance of a witness before ICAC in New South Wales who took their life after appearing before ICAC. I think we can all agree that that is too high a price to pay. So applying the best practice principles that the Integrity and Oversight Committee in 2022 outlined as described by Cathy, that in their report that really did focus on witness welfare, applying those will help prevent, we hope, that sort of event ever happening in Victoria. Over the past 12 months, anyone who's been reading paper or media will realise there's been a strong focus on witness welfare in integrity body investigations and on the circumstances that justify a public examination as opposed to a private examination. And I think in the VI, we are proud of the fact that in 2018 we were ahead of the debate in that report that we distributed on witness on the welfare of witnesses caught up in some investigations. And we have reason to be confident that with our refreshed welfare practices, informed as they are by professional input, that we can spot a real welfare concern before a witness is asked to go and sit over there. And we carry that alertness to witness welfare issues through to our review of examinations, whether it's conducted by IBAC, Ombudsman, or anyone else with the power to hold a private examination or a public examination. We carry that over and always bear that in mind in what we are looking at. And of course, we must always remember that we have a job to do, that you wouldn't be examining a matter if there was not some important matter to consider, that inevitably being brought into an examination, whether it's public or private, is likely to cause feelings of stress and discomfort. Appearing here or before IBAC or Ombudsman in a course of examination is no picnic. But we have a duty of care in doing that. We must protect you as best we can from any unnecessary and foreseeable harm. Now, precisely where the line is drawn between transparency and welfare, I think is ultimately a matter for Parliament. In the VI and in other integrity bodies, our role is to apply the legal framework within which we operate, and to the extent that that framework allows for the exercise of discretion, to exercise that discretion on a principled and on a consistent basis, applying best practice principles. So I'm very conscious of the fact that the job we have to do here is not an easy one, nor is a job that IBAC has to do, or the Ombudsman. These are difficult jobs. They require a careful, thoughtful, balanced approach, being conscious at all times of the competing considerations that must be factored into making any decision. Walking the line can be a difficult balancing act, but it's what the Parliament expects us to do. So there's nothing else. I guess it would just be a matter of thanking everyone for coming along. I hope you go away with this understanding that these questions are not easy, and there are balances to be had. And while the media reporting can sort of put it in a very easy, as if it's an easy matter, there's a lot more to it. Okay, well, thank you very much for coming along. Thank you.